What is a supplemental claim, and should you file one in your fight for VA benefits? In my oversimplified definition, the way I describe it is when you want the VA to redecide your claim with information that they didn't have the first time around, or at least the last time they made a decision. And when can you file it? Well, pretty much whenever you want, as long as you're filing it in response to a VA decision. There are some instances where you can switch your appeal lane, as it were, but that's a separate video for another day. For right now, if you get a decision and you've got new evidence and relevant evidence, you can file a supplemental claim at any time. But the key there is that you do have to include new and relevant evidence. If you don't include that, the VA is just going to send you a letter that says, we don't have any new evidence, so we can't redecide your claim. And so they're not going to do anything with it. And it makes sense, because if you're not giving the VA anything new, you're essentially asking for a higher level review. And if that's what you want, then that's what you should do if you don't have new evidence. So what is new and relevant evidence then? Well, new evidence is anything that was not before the VA when they decided your claim. Anything. It doesn't have to be new in the sense that, it's a medical record that was created a week ago, or a brand new statement from your buddy. It could have existed for a while. It just has to be something that the VA didn't have in front of it when it made the decision on your claim. What's relevant evidence? Relevant evidence is something that tends to prove or disprove one of the important parts of your claim. So, for example, one of the elements of service connection, the extent to which you're injured or your injury or disability affects you. So that gets to the percentage at which you're rated. Your eligibility for VA benefits, if that's at issue in your claim. So relevant evidence is something that tends to prove one of those things or disprove them. But for your claim, you're not trying to give the VA evidence that disproves your claim. That's just silly. Let me walk through an example. So let's say the VA service connects you for PTSD, but they rate you too low. Let's say you had a great lay statement from your spouse that talks about how you were a totally different person after you came back from deployment, and it walks through in great detail all of the effects that PTSD has had on your life and your ability to function with your family, function in society, everything. It's a great statement. And you had it, but you just didn't submit it with your claim. You can file a supplemental claim and include that lay statement and only that lay statement and get the ball rolling. And the VA will take that, look at that and say, is it new? Yes, because the VA didn't have it before. Is it relevant? Yes, because it tends to prove, the effects of the PTSD on your life, which is going to get at those percentage ratings that you're trying to increase. So they will take that statement and re-adjudicate your claim. And that's all you need for a supplemental claim. Now, I'm not going to stand here and say that one statement is going to, make a huge difference in the outcome of your claim. It may not. That depends on the specifics of your situation. What I'm talking about is what you need to reopen a supplemental claim with the VA. As another example, and this gets to relevant evidence. The other thing you can do that's relevant is present the VA with a new theory of service connection. What's that? Let's say you've got sleep apnea and you file a claim for direct service connection, as in, your service caused your sleep apnea, and that gets denied. You can file a supplemental claim and say, no, as an alternative, I wouldn't say, no, it's not this, it's this. As an alternative means of service connection, it was your traumatic brain injury which caused your sleep apnea. That is a secondary service connection, and that's a new theory, and that can be the basis of a supplemental claim. Now, if you're on your game, you would have given that to the VA the first time, but I don't want to go down too far on random hypotheticals. A couple other things about supplemental claims. If you want to keep your effective date, you have to file your supplemental claim within a year of the VA's most recent decision on that issue. If you miss that, then the VA's decision will be considered final, and you're going to lose any past due benefits you may have had on the table. 10 years down the road, 40 years down the road, if you've got new and relevant evidence, you can file a new supplemental claim, but your effective date is going to be the date you filed that claim. You've lost all of that stuff in the past. So be aware of that. Deadlines are critical, but I'm sure you guys already knew that. The other thing about supplemental claims, the VA does have a duty to assist. So if you file a supplemental claim, say something like, I was treated at a certain military hospital while I was in the service, those treatment records are relevant to my injury, the VA has a duty to go get those records, bring them back, and then redecide your claim. So I hope this information was helpful. As always, if you'd like help with your VA claim, feel free to reach out to me through my website, walshvetlaw.com. A link is in the description below. Thanks for watching.